Medical Negligence, Video 3, Topic Paediatrics. Based on the consumer case number 300 of 2013, order dated 18/4/2024 of the National Consumer Disputes Redressal Commission. Disclaimer. This channel creates awareness of medico-legal cases based on the judgment, order of the Honourable Supreme Court, National and State Consumer Redressal Disputes Commissions. For ease of reference, a summary of judgment order is discussed. For full details of the case, one must refer to the judgment order of the case. Facts of the case. Complainant number 2, mother, conceived and took 10 antenatal checkups with opposite party number 1, that is obstetrician. Ultrasonogram was done at various dates which showed everything was normal. Basic blood tests were taken and found normal. Mother was admitted at opposite party number 2 hospital and the obstetrician tried induction of labor but could not succeed. Hence, the obstetrician did LSCS on 5/11/2011 at 3 p.m. Opposite party number 3, pediatrician, attended the complainant number 1, that is newborn baby, and informed that the condition of the baby was normal. Mother was discharged on 8/11/2011. In the discharge slip, the pediatrician noted icterus on face and chest and advised exposed to early morning sunlight daily for half an hour for 7 days. On the next day, mother noticed the baby was severely yellow and jaundiced and consulted the pediatrician on 10/11/2011. The pediatrician examined the baby and suspected the development of jaundice and advised admission to another hospital for further management. During the admission, the baby's bilirubin was 48.5 mg per deciliter. Referral ranges 2.5 to 15 mg per deciliter. The pediatrician treated the baby for 10 days and discharged on 20/11/2011. After some time, the parents noticed something unusual in the baby. The pediatrician examined the baby and found baby was able to hold his neck partially. There was loss of hearing, delayed milestones, and prescribed some medicines. The parents complained. Even at this stage, the pediatrician could not diagnose a real disease or inform parents about the actual damage caused to the baby. After several months, when there was no improvement, the parents approached a pediatric neurologist on 16/8/2012 who obtained a report of an MRI of the brain and informed that irreparable damage was caused to the brain of the baby due to jaundice. The second opinion obtained from another doctor described the findings as suggestive of kernicterus. The complainants took advice and medicines from various doctors, one after other, but with no improvement. Complaint before the National Commission. The baby, through his parents, and the parents presented a complaint before the National Commission that, as per AIMS NICU Protocol of 2007, any newborn discharge prior to 72 hours of life should be evaluated again in the next 48 hours for adequacy of breastfeeding and progression of jaundice. Earlier and more frequent follow-up should be provided for those who have risk factors for hyperbilirubinemia. Clinical judgment should be used in determining follow-up. The protocol provides for, inter alia, the following risk factors for the development of severe hyperbilirubinemia is pre-discharge total serum bilirubin or transcutaneous bilirubinemetry level in the high risk zone, jaundice observed in the first 24 hours, and blood group incompatibility with a positive direct antiglobulin test. The opposite parties committed gross negligence in discharging before 72 hours of the birth of the child. From 5/11/2011 to 8/11/2011, the opposite parties did not test serum bilirubin. At the time of discharge from the hospital on 8/11/2011, the pediatrician noticed icterus on face and chest and advised exposed to early morning sunlight, that is physiological care and not clinical management. Even then, he did not test serum bilirubin. Bilirubin was found 48.5 mg per deciliter on 10/11/2011, which cannot reach such a high level in a single day. Due to not diagnosing jaundice at the initial stage and not providing proper medical care, even after noticing jaundice on 8/11/2011, the condition of the baby had become serious within 5 days of his birth. High-level bilirubin caused permanent damage to the brain of the baby. Even after 2011-2011, the pediatrician attended the baby several times, but he did not inform the parents of the damage caused to the brain of the baby. Due to negligence committed by the opposite parties, the baby suffered from kernicterus, that is damage to the vital part of the brain. If proper diagnosis and treatment of jaundice had been done at the initial stage, the baby could have been saved from incurable disease and permanent disability. For physiotherapy expenses, permanent disability, future medical treatment, the cost of cochlear implants for the baby, mental trauma, and loss of income for the mother, the baby and parents filed a complaint for directing the opposite parties jointly and severally to pay Rs 3 crores 5 lakhs and 60,000 as compensation for committing medical negligence. Written version of the obstetrician and the hospital. The obstetrician and the hospital in the written version admitted to the above facts till the admission of the baby at the other hospital, that is 10/11/2011. The bilirubin level on 10/11/2011 of 48.5 mg per deciliter was not suggestive of the fact that the child suffered from jaundice since his birth. The baby was treated till 2011-2011 and a second opinion was also taken from a consultant neonatologist of another hospital. After discharge, the parents visited the pediatrician a couple of times. The parents were advised to follow for neurodevelopmental sequelae and hearing assessment. It has been denied that the child had suffered from irreparable brain damage or permanent disability. It has been denied that the opposite parties have committed any negligence in taking care of the newborn baby. The complaint is liable to be dismissed. Written version of the pediatrician. The pediatrician was present to attend the newborn baby at that time of delivery. The baby cried immediately at birth and the weight of the baby was 2.7 kg. He checked up and found that the vitals of the baby were normal. He examined the baby on 8/11/2011 around 3:30 p.m. and noticed minimal jaundice in the baby. In the discharge slip of the baby, he noted icterus on face and chest. The pediatrician counseled the mother and informed her about minimal jaundice in the baby. As symptoms of jaundice were up to the face and chest, conservative line of treatment was advised with instructions to follow within 24 hours. Mother was advised to continue breastfeeding, avoid oil massages to the baby, expose the baby to sunlight in the morning. As per practice, mother was discharged from the hospital on the 4th day after 72 hours of delivery on 8/11/2011 at 4 p.m. The parents of the baby were told to keep a close watch on the jaundice and if it increases, contact the pediatrician immediately. Over the next 48 hours, there was no communication from the parents. Usually, pathological jaundice used to develop within 24 hours of the birth. As there was no symptom of jaundice within 24 hours As such, serum bilirubin or transcutaneous bilirubin was not required. Icterus on the face and chest on the third and fourth day of the birth is physiological jaundice. The complainants visited the hospital on 10/11/2011 and the pediatrician found the baby deeply icteric with a refusal to feed, lethargic and tonic posturing. The pediatrician advised to shift the baby to the NICU of another hospital immediately. In view of the bilirubin level of 48.5 mg deciliter, a double volume exchange transfusion and the G6PD enzyme test were done. Due to acute hemolysis, the said deficiency was not detected at that time. In view of CRP being strongly positive and the low platelet count, the doses of antibiotics were stepped up to meropenem and amikacin. A second opinion was also taken from a senior consultant, neonatologist and pediatrician who advised to continue the same line of treatment. Paxil transfusion was administered to the baby in view of falling hemoglobin. Repeated serum bilirubin showed a decreasing trend and gradually the activity and the general condition of the baby improved. Breastfeeding started and gradually stepped up. The baby was discharged on 20/11/2011 and on full feed. The pediatrician advised the parents to ensure that the child undergo neurodevelopmental assessment, EEG monitoring, neuroimaging, physiotherapy, brainstem evoked response audiometry, hearing and ophthalmological assessment as also noted in the discharge slip. Parents brought the child to the pediatrician for follow-up and vaccinations for a few months. The pediatrician observed delayed milestones in the baby and counseled the parents regarding likely complications and prognosis in detail. Later, the pediatrician was not consulted by the complainants after 23/3/2012. The complication in the child arose due to G6PD deficiency induced severe neonatal hyperbilirubinemia and kernicterus. The opposite parties adopted standard protocol and have not committed any negligence. It has been denied that the child had suffered from irreparable brain damage or permanent disability. An exorbitant claim has been made in the complaint without any basis. The complaint is liable to be dismissed. The expert opinion. The Commission called for an expert's opinion from a board of medical experts from the AIIMS, New Delhi, and a report dated 17/10/2022 was submitted. Mother and baby were discharged on 8th November 2011. At the time of discharge, the baby had icterus up to the face and chest, which is normal physiological jaundice. As per the standard of care prevailing in the country at that point in time, jaundice of this severity does not warrant any investigation in a term baby weighing 2.7 kg. Unlike Western countries, India does not have the guideline of universally screening neonates for total serum bilirubin levels at discharge. The baby was admitted to another hospital on 10th November 2011 with complaints of refusal to feed and lethargy. Upon investigation, it was found that the bilirubin level was 48.5 mg per deciliter. The baby was diagnosed having sepsis with neonatal hyperbilirubinemia with encephalopathy and hypocalcemia. A G6PD test was conducted, but the result came to be negative. We agree with the assessment of treating team and the baby suffered from acute bilirubin-induced encephalopathy. There was no blood group incompatibility. The treatment team provided appropriate management for the baby's condition. The baby was later diagnosed with G6PD deficiency as per the test conducted on 6th August 2012 when the baby was 9 months old. The presence of G6PD deficiency explains the severe hyperbilirubinemia in the baby on the 5th day of life, causing brain damage and kernicterus. The baby died due to kernicterus later. An infant with G6PD deficiency can develop a sudden and extreme increase in the total serum bilirubin that can cause bilirubin encephalopathy that is hard to predict or prevent at discharge. Please see the highlighted text in the recently issued American Academy of Paediatrics guidelines, the most authentic resource on the subject, page number 4. Currently, India does not recommend screening neonates for G6PD deficiency. During admission on the 5th day of life, the baby was not found to have G6PD deficiency. This is known to occur following a bout of hemolysis causing severe hyperbilirubinemia. The G6PD test can come normal. It is therefore recommended to repeat the test after 3 to 6 months, which was done in this case. Conclusion by the expert. Unfortunately, the child had severe jaundice due to G6PD deficiency. The parents finally lost the precious child. However, we do not find any deficiency on the part of the teams providing care during the birth, hospitalization, and later when the child was admitted with severe hyperbilirubinemia on the 5th day. Both teams provided care as per the recommended guidelines. The National Commission's order. The allegation that the mother and the newborn baby were discharged before 72 hours of birth is not proved in as much as the birth took place on 5/11/2011 at 2:58 p.m. and the mother and the baby were discharged from the hospital on 8/11/2011 at 4 p.m. Neither any allegation nor evidence that symptoms of jaundice were found within 24 hours of the birth of the baby. Symptoms of jaundice were noticed on the face and chest of the baby on 8/11/2011 at 3:30 p.m. Only on the basis of the fact that the bilirubin level was found to be 48.5 mg per deciliter on 10/11/2011, it cannot be presumed that the baby was suffering from jaundice since birth, particularly when glucose 6-phosphate dehydrogenase deficiency was found in the child, which caused severe neonatal hyperbilirubinemia and kernicterus, which is a rare complication. The parents were asked for a review within 24 hours of discharge, but they did not turn up for review within 24 hours and there was no communication for 48 hours. From the material on record, it is proved that the pediatrician advised for physiological treatment as the jaundice on the face and chest was found 24 hours after the birth of the child as per AIIMS NICU Protocol 2007. The Medical Board of AIIMS in its report dated 17/10/2022 found that the pediatrician has not committed any negligence, which appears to be correct. G6PD reports were obtained, but due to low blood count, its report was not properly shown. In this order, the Supreme Court judgment of Jacob Matthew versus State of Punjab 2005 6 SCC 1 is cited for the following points. A simple lack of care, an error of a judgment, or an accident is not proof of negligence on the part of the medical professional. So long as a doctor follows a practice acceptable to the medical profession of that day, he cannot be held liable for negligence merely because a better alternative course or method of treatment was also available, or simply because a more skilled doctor would not have chosen to follow or resort to that practice or procedure which the accused followed. When it comes to the failure of taking precautions, what must be seen is whether those precautions were taken which the ordinary experience of men has found to be sufficient. A failure to use special or extraordinary precautions which might have prevented the particular happening cannot be the standard for judging the alleged negligence. In view of the aforesaid discussions, the National Commission dismissed the complaint, that is, the opposite parties, obstetrician, hospital, and the pediatrician, were not committed any medical negligence. Points to be noted from this case. When treating the patient, standard protocols, prevailing practice, and medical guidelines should be followed. All the instructions given to the patient and the date for review must be noted in the patient's medical records. The patient's medical records must be correctly kept. When necessary, treating doctors should immediately seek a second opinion from the specialist and record their findings in the patient's medical file. If the hospital lacks the medical facilities, that is, specialist, equipment, etc., required to treat the patient, should refer the patient to a higher institution. Thank you for watching the video.